In the fight against terrorism, there is absolute need to balance the right to information with the commensurate duty to ensure that terrorists do not use media reports to achieve their deadly ends. The state has to be innovative in fighting terrorists, but within the framework of the Constitution, and particularly the Bill of Rights. The media must also be careful not to give solace and comfort to terrorists by publication of images that may be taken to glorify and give impetus to acts of terrorism. The roles of the speakers of the two houses have come into sharp focus, whereas we have found no ruling on their part based only on the evidence before us, and no more, it is incumbent upon them to ensure that the constitutional standing order obligations are undertaken to the highest standards. The respect and dignity of the two houses can hardly be maintained if the chambers are turned into anything other than hallowed legislative temples.
The state suffered a second blow after a 5-judge bench ruled to uphold several decisions passed by Judge George Odunga, who suspended the implementation of certain clauses in the security bill over violating the Constitution. The judgment that was delivered for close to 4 hours saw the judges nullify Sections 12, Section 64, Section 34, Section 16, Section 20, Section 26, Section 48 and Section 95 of the Act on grounds it failed to uphold the freedoms enjoyed by Kenyans through the 2010 Constitution.
Section 12 of the Security Laws Amendment Act and Section 66 of the Penal Code is hereby declared unconstitutional for violating the freedom of expression in the media guaranteed under Articles 33 and 34 of the Constitution. Section 64 of the Act, which introduced Section 30 of the Prevention of Terrorism Act, is also declared unconstitutional for the same reasons.
Attempts by the Coalition of Reforms and Democracy to have the entire act invalidated by providing proof of a 10-minute video of the proceedings in which they argued was chaotic was however dismissed by the judges. In dismissing the argument by court, the judges said from their perception, legislators were engaging in loud consultations and there was no proof of actual violation of the House standing orders. At the same time, the judges ruled there was no evidence showing the Senate Speaker had failed to be consulted prior to the passage of the law.
Section 95 of the Act, which introduced Section 95A, the National Police Service Act, and the National Police Service Board, is declared unconstitutional for violating Articles 246(3) of the Constitution.
Court has argued that the new laws contradicted the provision of the Bill of Rights, which made them null and void. Some of the provisions challenged, including giving police and the National Intelligence Service permission to arrest and hold terror suspects for up to 360 days, and reduction of the number of refugees in Kenya to 150,000.
We're happy to note that the 5-judge bench has upheld